May it please the court, my name is Rottgering initial V, that is Rottgering, and I appear today on behalf of the defendant. The defendant is currently being accused of 9 counts of breaking and entering and 1 count of stealing. The defendant submits an application under Section 590AA of the Evidence Act for the current matters. We submit that Mr. Selder's admissions to the charges are to be deemed inadmissible as evidence. Your Honors, the Crown's case is solely based on improperly acquired admissions during formal questioning in the presence of the support worker, Wendy, as well as during informal questioning in the police officer's car. As per the principle found in Goldsmith and Sandylines, these admissions are highly relevant to the case and prima facie admissible. We submit, Your Honors, that the probative value of this evidence is highly outweighed by its prejudicial effect and therefore should be excluded pursuant to Section 130 of the Evidence Act. Your Honors, Section 130 incorporates the extremely important judicial discretions present in common law, and those are the fairness discretion that was first analyzed in the case of Christie and the public policy discretion analyzed in the Ireland case. The defendant submits that the court must apply its judicial discretion following the fairness principle due to the evidence's low probative value in comparison to its high prejudicial value. Your Honors, we submit that the admissions made are to be taken in consideration with the young age and cultural background of the accused. Darren is a 14-year-old Torres Strait Islander. As portrayed in the Equal Treatment Bench Book, which reflects the facts present on the case of the Crown and Kennedy, an Aboriginal person is likely to gratuitously concur with a proposition put to them by a person with authority in an oppressive situation as means of conveying cooperation and avoiding conflict. This phenomenon, Your Honors, can be identified on the present facts as the accused avoids eye contact and limits his answers to simply one-word responses such as yeah, as well as being in a highly oppressive situation as being questioned by the police. Therefore, Your Honors, as described on cases such as Hasler and Lee, if such admissions were to be allowed as evidence, they would have an adverse and unfair effect on any jury, concluding that the court should find the evidence inadmissible on the fairness discretion. The defendant further submits that the court should find on the grounds of public policy that the evidence is inadmissible. The defendant submits that the arresting officer showed no attempt to follow the rules imposed by the Police Powers and Responsibilities Act, therefore demonstrating a clear breach pursuant to Section 7 of the same Act. Section 7 states that Parliament's intention, which adopts the principles of the famous case of Bunning and Cross, where police officers should comply with legislation in exercising their powers and performing their responsibilities. Such breaches, Your Honors, were done so deliberately and recklessly by the police officers. Your Honors, my apologies. In accordance with provisions 436 until 439 of the PPRA, it has become a statutory requirement that any confession to an indictable offense, such as the breaking and entering and the theft accusations, must be electronically recorded. Your Honors, Section 436, subsection 3, actually states that any confession made by a person to a police officer will only be admissible in evidence if it is recorded. The arresting officers have further breached Sections 420 and 421, which refer to the questioning of minors and Aboriginal people. As the officers did not, upon arrest, instruct the accused of his rights to have a support person of their choice present prior to answering any of the questions, Your Honors, as well as that a representative from legal aid would be contacted and informed of the accused's arrest. Your Honors, this was not done at all. Although Section 412 does allow a detained person to be taken to a place other than a police station, it does not overrule the fact that the accused is a minor and should not be questioned prior to meeting its support person or lawyer. Based on the transcript, Your Honors, the defendant was questioned while being driven by the crime scenes of his alleged crimes, and due to his aboriginal disadvantage of gratuitously concurring with statements, he has admitted to the offenses by answering yes to all the questions asked of him. My apologies, Your Honor. Therefore, making it clear that his first admission to the police officers should be excluded. Upon arrival at the station, Mr. Seller was handed over to his imposed support person, whom was a person he had never met. This further demonstrates the Crown's breach of Section 420, as the defendant was not given a choice of his own support person. Further, Wendy, the social worker, advised Darren to make sure he answered all the questions of the officers asked of him, instead of instructing him that he had the right to remain silent, and he had no need to answer any of the questions without a lawyer present. In the current situation, it is possible to infer that the admission recorded was done so due to Wendy's apparent influence over the child, Darren, and his cultural tendency to concur when under pressure. Your Honors, this clearly shows a breach under Section 85 of the Evidence Act, as he was clearly induced to admitting the crime. Your Honors, since the Crown's evidence rests on this evidence alone, and the defendant and the facts, my apologies, Your Honor, Your Honor, we move that the court should find that the evidence should be found inadmissible for the factors just addressed, and the respondent submits no prima facie case and has been my apologies, Your Honor. We submit that no prima facie case has been made by the Crown, and therefore it should be dismissed for want of evidence pursuant to the case of May and O'Sullivan. Thank you very much, Your Honors.